A very pleasant evening to honorable guests, my respected teachers, and all intellectual participants. On behalf of KLE Societies, KLE College of Law, Navi Mumbai, I, Khushbu Kothari, welcome you all. I will be hosting today's session along with Professor Pooja Bijargi ma'am, who will be moderating today's event. Our guest speaker for today, Advocate Pralhad Paranjape sir, has joined us. A very warm welcome to you, sir. Today, sir is going to enlighten us on environmental law and its impact in India. Now, I would like to request our principal, sir, to address our guest speaker and participants.
Over to you, Khushbu. Thank you. A very good evening to one and all. A very warm welcome to our guest speaker, Advocate Pralhad Paranjape, Bombay High Court. Thank you, sir, for accepting our invitation and joining us to share your views for today's session. And I'm confident that our dear participants would learn a lot from you today. And to bring it on record, Pralhad and myself share, we are alumnus of DES Law College. And he's a very good friend of mine. And let me bring it on record. He's a very good mooter, debater, and a very successful lawyer. And he has representing many big and important clients in Bombay High Court. So, sir, on behalf of KLE Societies, KLE College of Law, I welcome you to this session. I am also obliged to the KLE management, especially Dr. Prabhakar Koreji, chairman of KLE Society, who is a consistent inspiration for all of us. Mr. Mahantesh Kavadgimat, governing body chairman, KLE College of Law, MLC and Chief Whip Karnataka government, who keeps on giving us new ideas. Dr. Mallikarjunaya, who is our mentor, the principal of KLE College of Law, Bangalore, all the participants across the country, and my dear students, all faculty members, all the volunteers. I hope without wasting much of our time, I would like to hand over this session to Professor Pooja. I request Professor Pooja to carry forward the session as scheduled. Thank you.
Thank you so much, Principal Sir. With immense pleasure, I would like to introduce the guest speaker for today, Advocate Pralhad Paranjape sir. Sir has started his career in Bombay High Court. He has handled several matters including civil, criminal, company and arbitration proceedings, independently in Supreme Court, High Court and various other tribunals like NCLT and NGT. Sir has assisted various senior advocates including Advocate General of Maharashtra, Attorney General for India and Additional Solicitor General, New Delhi. Sir presently practices in Bombay High Court and Supreme Court related to various subjects like constitution, civil, company, land acquisition and criminal matters. Sir has appeared in various constitutional matters and civil cases at Supreme Court and High Court for state of Maharashtra like Mahar Metro Rail Corporation Limited and Nagpur Metro. Sir has also appeared in High Court for National High Speed Rail Corporation of India, NHSRCL, which is executing the bullet train project. Sir has represented Pune Metropolitan Region Development Authority, PMRDA, and has defended the Line 3 Metro project in High Court. Besides, Sir has been dealing with medico-legal issues right from the beginning of his practice. He has advised Kolhapur Medical Association and has also appeared for and defended the rights of practitioners of Indian system of medicine, both in High Court and Supreme Court. Sir has also represented the National Integrated Medical Association, NIMA, and Maharashtra Homeopathy Council. With this brief introduction, I welcome you, sir, and I am sure the participants would enjoy the session and would gain a lot of knowledge. Over to you, sir.
Thank you, ma'am. At the outset, I would like to thank the management of KLE Law College for inviting me today. It's a very humbling experience to be called to a college to deliver a talk on one of your favorite subjects by one of your favorite friends. Me and Dinkar Principal Dinkar go back a long way. We've studied together. We've spent a lot of moments reading and studying together. And it gives me great joy, immense pleasure to address you all today. Sorry, am I audible? Is it?
Yes.
Yes, sir,
You
you're
are
audible.
audible, sir. Yes.
Friends, the subject today which I have chosen is environmental law and its impact in India. At the outset, I must say that environmental law is and has been one of my favorite subjects. Being a practicing lawyer, it has also given me many opportunities to appear and participate in many matters relating to environment. Sometimes for project proponents, sometimes for individuals, sometimes against the project proponents. Overall, it has been a great learning experience. When I was asked upon by Principal Dinkar to figure out a topic, I said, why not take environmental law? Because we are facing one of the greatest challenges in environmental law in India today. And why not try and give you all a brief insight into what is the nature of environmental law and its impact in India? At the outset, I must say that what do you mean by environment? Environment, friends, means our natural surroundings. Environment encompasses the right of not only us, but also plants, animals, and all other living organisms to sustain together, to live together, to grow and operate naturally in our surroundings. Now, having looked at the definition of environment from this broader perspective, what is the statutory framework which will govern this sort of a vast topic is the next question that will come to our minds. Friends, in India, in the year 1972, we participated in a global conference on environment called as the Stockholm Conference. This Stockholm Conference lays, in my view, a basis for many of the statutory laws governing environment in India. So by Stockholm Conference, it was decided that the participating countries and signatories would enact laws which would be standardized in accordance with the UN terms of the conference so as to protect environment in all its forms. By all its forms, I mean air, water, sound, chemicals, and all other forms of pollution should be prevented. So what happened after the Stockholm Conference of 1972 was that the Indian Constitution was amended. So what exactly was amended? Part 4 of the Indian Constitution deals with directive principles of state policy. Now, we all know that directive principles of state policy are not enforceable like fundamental rights, but they come immediately after Part 3 and assume a great importance. So, in 1972, the 42nd Constitutional Amendment introduced Article 48A, which carved out a responsibility of the state to protect the environment in India. So this is for the first time after 1972 Stockholm Conference that we have a constitutional amendment by which it was directed that the state would provide for safeguarding of the environment. Now, similarly, one interesting aspect which took place at that point was that Article 51AG, which dealt with Chapter 4A of Fundamental Duties, was also amended to correspondingly make it a duty of every individual, every citizen of the country to protect environment in its form. Friends, it was very important to have this corresponding duty as well. In my view, while the jurisprudence of the court, and I will come to that during the course of my talk today, while the jurisprudence which the court has developed has to a great extent taken its view from Article 48A, we must, as citizens of this country, also not forget our fundamental duty under 51AG to protect the environment. Friends, I chose this topic so that I could give you some brief overview of how we can also participate in saving of our environment, in safeguarding of our environment, while understanding the statutory framework. So when we had these constitutional amendments, let us now see what happened post the constitutional amendments. The first law in point of time in independent India was the Water Prevention and Control of Pollution Act of 1974. We all know, friends, that in India, we were facing several issues relating to water pollution. And it was thought necessary and expedient to have a law which will deal specifically with water as a subject. Now, there was a difficulty in even enacting this law because Part 2 of the Constitution provides that only those subjects which the states could formulate laws for. And therefore, in this case, as a special measure, the states had to give their consent under the constitutional framework for the central government and the parliament to enact a central law. Thankfully, all the states gave their consent, majority of them did, and therefore the Water Prevention and Control of Pollution Act of 1974 was enacted. It constituted under its ambit various boards to see that the water pollution was prevented, to see that many industries, many organizations, many rivers which were being polluted were stopped. The polluting industries would be held responsible for the kind of pollution that they would create. And for the first time, a statutory framework in form of a central legislation was enacted. This was in the year 1974. Now, that followed by a lapse of 6 years, or rather 7 years. And then the Air Prevention and Control of Pollution Act of 1981 was enacted. Thus, first we had Water Pollution Act, Water Pollution Prevention Act, and then the Air Prevention and Control of Pollution Act of the year 1981. Similar to the norms established by and under the Water Pollution Prevention Act, the Air Prevention and Control of Pollution Act also established various boards and also established various authorities and regulatory framework so as to prevent the pollution of air. Various industries, various organizations, various types of air pollution was sought to be curbed by bringing out a substantive legislation known as the Air Prevention and Control of Pollution Act of the year 1981. So by that time, we had two different laws. What followed thereafter was the Environment Protection Act of the year 1986. Now, this is one of the most important statutes because for the first time, this statute collated various aspects of laws governing air pollution, water pollution, even noise pollution, even other forms of pollution, which we still deal with in our country. The Environment Protection Act was formed on basically the recommendations issued by the United Nations in the Stockholm Declaration. So, what were the important recommendations? The recommendations included having central framework so as to prevent various forms of pollution. The Environment Protection Act of the year 1986 was a comprehensive act thus enacted, which also included in section 15 penal provisions for those who would pollute the environment. Of course, there were various norms under which penal action could be taken, penalties could be imposed, even penalty like prosecution could be opened against individuals who would pollute the environment, but they were all within the statutory framework of the Environment Protection Act. So wide powers were given to various authorities which were formulated under the Environment Protection Act. Now, this is as regards the three acts as under the Environment Protection Law. In 2000, under the aegis of the Environment Protection Act, we also had the Noise Pollution Regulation and Control Rules. So for the first time, the noise decibels were sought to be regulated under the noise pollution rules, which were earmarked under the provisions of the Environment Protection Act. So if you would have a violation of the noise pollution rules, or if you had a violation of any of the laws, you would be penalized under the provisions of the Environment Protection Act. Thus, overall, the statutory framework in relation to laws of the environment revolves around these three acts, these three primary acts. The most important being the Environment Protection Act, which considers in its ambit the provisions of the Water Act of the year 1974, the Air Act of the year 1981, and then the noise pollution rules of the year 2000. Now, friends, are these the only acts which govern the environment? Well, no, these aren't the only acts which govern laws relating to environment. But to consider the impact of the environmental laws in India, we must also take into account two other aspects of law. One of the very important aspects of law is the law relating to forests. And this is a pre-constitutional act, a pre-independence act, the Indian Forest Act of the year 1927. Now, of course, that has also been followed by a post-independence act, the Forest Conservation Act of the year 1980. But what exactly was done by the Indian Forest Act was that various categories of forests were drawn forth. Now, these categories included reserved forests. So, for the first time under the Indian Forest Act, a category of forest known as reserve forest was brought into effect, and therefore, various restrictions on activities permissible in these reserved forests or areas were also brought out by the Indian Forest Act of the year 1927. The Forest Conservation Act of the year 1980 gives more teeth to the Act of the year 1927. Friends, in around the time the Forest Conservation Act was enacted, we realized that although there was one act present, we required more analysis, we required more in-depth research, we required more information as regards various violations of the act. And we therefore came to a conclusion that we required another statute. And this led to the enactment of the Forest Conservation Act. The whole purpose of the Forest Conservation Act, in a nutshell, is to protect the forest in its forms as they are, so that the green cover in India can be maintained. We all know today that we are faced with a dwindling situation of forests. And therefore, the Forest Conservation Act was a very important piece of legislation which also restricted the usage of various activities which was otherwise permissible in the pre-constitutional, pre-independent statute. Thus, the legislature, by introducing this act, also wanted to see to it that the proportion of the forest would not be reduced, the green cover and the environment in its pure form would be maintained. And therefore, these two acts are the primary legislations and the basic legislations governing the law of forests in India. Now, that is not the only law which also has an overall impact on the environment in India. Another very important law is relating to wildlife in India. Because as I began, I had told you that environment includes all living forms in harmony and coexisting together. Therefore, we cannot reduce the importance of wildlife. And therefore, in India, we've had the Wildlife Protection Act of the year 1972. Now, friends, this act is also very important because very many important issues which we face today were discussed, solutions were provided for in this very act itself. The Wildlife Protection Act, as the name itself symbolizes, has been enacted with a pious objective of protecting the wildlife in the country. We all are aware of one glaring example of wildlife protection. The dwindling number of tigers in between was an issue of great concern to everyone in India. We also had various ambassadors of the country making an appeal to all the citizens to protect and to conserve tigers. Now, how were those aims established and achieved? As of today, we have a much better population ratio of the tigers from the dwindling ratio that we had in between. This was achieved in accordance with the provisions of these two enactments, the Wildlife Protection Act and coupled with the Indian Forest Act. So what these acts, rather what the Wildlife Protection Act envisages is that First of all, hunting of animals is prohibited under this law. So, is it so that all kinds of animal hunting is restricted? No. Some basic animal hunting, like for example, we have a problem of wild boars in many parts of Maharashtra, wild boars who destroy forests. So therefore, all those animals who destroy forests, who destroy fields, they can be hunted in self-protection or for protection of your crops. But this act in its ambit puts a blanket on hunting activity overall. Therefore, this act also brings out various categories of animals which are reserved animals and which are to be protected under the statutory framework. So, which are these animals? Friends, we have all different kinds of wild animals which are protected under this act. They are also known as scheduled animals and whose hunting is prohibited. This has led to a great increase in the number of animals. I gave you all an example of tiger. There are many other such examples, but due to paucity of time today, I cannot delve into all of them. But yes, these three facets of law basically govern the law of environment in India. One are the three laws: the Environment Protection Act, the Water Pollution Act, the Air Pollution Act, of course, coupled with the noise pollution regulations. Two, laws relating to forest. And three, laws relating to wildlife. Friends, under the rule making power which is given to the central government as well as the state government under the Environment Protection Act, in order to meet the necessities of time, there are various other rules which are also enacted by various other state or the central government authorities. What are these rules, or which are these rules? What are these authorities? Very briefly, to touch upon these authorities, they include rules which are made or framed for hazardous waste, rules which are framed for disposal of biomedical waste. As the society is progressing, we are also realizing that with advent of technology, we are also facing a threat of diminishing environment. And therefore, in order to sustain and in order to protect the environment, we have enacted a slew of rules like the biomedical waste rules, the hazardous waste rules, the efflux rules, and many other rules. So therefore, these rules are subsidiary legislations which are operating under the aegis of the Environment Protection Act and the two central acts. These are briefly rules made also to protect and subserve the interests of environments under the brief laws which I have already mentioned. Therefore, there is no need to go into the detailed facets of these rules at this point of time. Now, having said so, what happens when there is a violation of all these rules, or what happens when there is a violation of all the provisions of these acts? Do we have a statutory framework also present in order to see to it that the violations are curtailed or the violations are stopped, or seen to it that the violations are fully restricted? Well, we all know that we come across a few cases once in a while wherein gross violations of the environmental laws and acts take place. In the year 1995, there was a declaration. In the year 1992, as I'm corrected, there was a global declaration, something on the lines of the Stockholm Declaration, called the Rio de Janeiro Declaration. Well, what was this global platform intended to declare? Or what was the declaration in the context of? I'll just explain. The Rio Declaration was a group of countries getting together to have a judicial framework in order to provide for specialized platforms to deal with various environmental violations. Thus, we had all the major countries coming together under the United Nations platform in order to provide for a very specific and a unique tribunal or a unique authority which would deal only with laws relating to environment. Now, this is very important. Because we all know that usually courts are interested with the duty of safeguarding the rights of the citizens as well as for penalizing citizens for any violations of the laws. We in India are already facing a burden on the judiciary in terms of pendency of cases. If we consider the population of India and if we consider the pending cases and the pending number of cases, we all know that the Indian courts are grossly overburdened. We know that the judge case ratio in India is almost abysmal in comparison to the judge case ratio, judge litigation ratio in various other developed countries, especially the Western countries, or say in America. We all know that the judiciary in India is already overburdened, and yet we still have to go to the higher courts or the constitutional courts several times in order to safeguard environmental rights, which are capsulated under Article 21 while approaching these higher courts. About those, I'll come to that in a bit. But therefore, what fell from the meeting of all the global countries was that there was a requirement of a tribunal, a specialized tribunal to deal with cases relating to environment. So what happened then? In India, in the year 1995, in accordance with the Rio Declaration to which we were a signatory, we enacted the National Environment Tribunal Act. So the environment for the first time got a tribunal to deal with its cases. Although I must quickly say that this tribunal really was not very effective. And although there were several cases filed in this tribunal, we all know the important cases were the declarations which were granted by various high courts and supreme courts in order to protect the environment. Those cases also I'll come to in a bit. But we know for a fact that this tribunal was not very conducive. Although it existed on paper, it never became an active tribunal or it never became a proactive tribunal. We all know that environment is a all-encompassing subject, a subject so vast that it requires a tribunal with vast powers. Thankfully, the first legislation, which was almost like a toothless tiger, was replaced by a more potent and a very good mechanism or a legislation, which was enacted in the year 2010. I'm sure all of you must have heard of it. That tribunal is known as the National Green Tribunal or the NGT. So in 2010, a tribunal was established known as the National Green Tribunal, which provided opportunities to the citizens of the country and all those who are interested in protecting or safeguarding the environment to approach the court seeking redressal of its grievances for protection of environment and all other related issues in terms of environment protection. So therefore, from the year 2010, we've had NGT. The statutory framework is such that the National Green Tribunal has its principal seat in New Delhi. The chairperson of the National Green Tribunal is a judge of the Supreme Court, either a sitting judge who then demits his office and takes over the charge of the National Green Tribunal, which happened in the case of Justice Adarsh Goyal when he became the chairman of the National Green Tribunal, or a former judge of the Supreme Court, which was the case with Justice Swatandra Kumar, who was the chairperson of the National Green Tribunal. The members of the National Green Tribunal also include judicial members, which are judges of the High Court, retired or presiding, who then demit office and join the National Green Tribunal as judicial members. The unique part about this National Green Tribunal is that it also has expert members. So therefore, the true purport and ambit of the Rio Declaration can be found in the enactment of the National Green Tribunal, which provides for adjudication of disputes relating to environment by members not only of the judiciary, but also of subject experts or expert members. So who are these expert members? Friends, all members, all various academicians, all those people who have vast knowledge of the environment, people who have worked for protection of environment, people who hold qualifications which are doctoral or more, and people with great experience in various environment protection schemes are appointed or eligible to be appointed as members or expert members of the National Green Tribunal. And this really is important because while examining matters relating to environment, we all know that as members of judiciary or as lawyers, we may have our restrictions when it comes to dealing with subject expertise. For example, in issues relating to what could be the nature of environmental compensation payable for flood victims or for any other victims, for air pollution victims or many other forms of pollution, which can be considered more appropriately by expert members who then sit along with the judicial members. So NGT, which has come into existence, has its principal seat in New Delhi. It has 4 zonal benches in order to see to it that there is easy accessibility of justice or of environmental justice to the citizens of the country. Apart from the principal bench, there is a bench known as the Western Zone Bench, which sits in Pune. There is a Eastern Bench which sits in Calcutta, which deals with all the matters coming in from that part. And then, if I'm not wrong, there is a bench in Chennai, which deals with all the matters in relation to South India. Currently, all the matters are conveyed via video conferencing due to the spread of pandemic COVID-19 in India. But therefore, there has been effective setup which has been established for providing measures for compensation and for protection of environment in terms of enactment of the NGT 2010. Appeals from the NGT are to be heard directly by the Honorable Apex Court of the Supreme Court. Thus, far-reaching statutory features are provided so as to see to it that the tribunal acts with full authority while dealing with cases of environment. From my personal experience, friends, I can always tell you that the NGT is really providing for a very effective platform. It is providing for a means of justice redressal and justice delivery system to see to it that the important topic of environment is not neglected or is not pushed behind due to the pendency of matters in the regular courts. Of course, the NGT has never taken away the salutary or the inherent powers of the writ courts or the Honorable Supreme Court under Article 226 of the High Courts and 32 by the Supreme Court. Therefore, although these courts can exercise jurisdiction in various issues, which also I'll come to, it is basically the NGT, which now is the central tribunal in India to deal with various forms of environmental pollution or environmental issues. Now, having given a brief overview of the laws which are existing in India, I would like to come to the second part of my talk. And this, friends, is a little interesting because here I would like to deal with various important cases which we all might have heard of and would like to briefly give an explanation or a small background of these cases. These are not many cases, about 8-10 cases, which I felt were of great importance. And at the end, I would like to deal with my experiences while handling environmental law related litigation or legislation. Friends, the law of environment has been greatly expanded by judicial pronouncements on the issue. Most of them are judicial pronouncements declared by the Honorable Supreme Court, which then becomes the law of the land, and many other cases which are judicial pronouncements given by the high courts, which also have a binding effect in the states concerned. So, which are these important cases? Well, to begin with, one must take Mr. MC Mehta's name when it comes to environmental law related cases. We all, as students of law, have heard of a slew of MC Mehta cases. But let me tell you all one very famous story about Mr. MC Mehta. Mr. MC Mehta went to visit the Taj Mahal, and there he saw that the Taj Mahal was getting affected by the polluting industries around the Taj Mahal. And this is when his foray into environmental litigation or environmental cases really began. I'll come to his cases, but there is another story about Mr. MC Mehta, who's also now a lawyer and who practices in environmental law cases himself. And this story goes that while addressing the Supreme Court, he had carried with him 2 bottles of water. The water was completely dark in color and it could never be seen as being potable or drinking water. The respondent had contended, Mr. MC Mehta was contending that the industries were polluting the water and those industries should be stopped and prevented from polluting the water. The respondents were, of course, contending that no, the water was never being polluted. So Mr. MC Mehta pulled out those 2 bottles and said that, look, this is the water, which is the effect of all the pollutants which are being let in the water by the industries. Now I dare the respondent to drink this water. Of course, the lawyer for the respondent rightly refused. And then Mr. MC Mehta posed the same question to the judges of Supreme Court and asked them to drink that water. Of course, they also never drank it. And this kind of led to one of the major cases in laws for protection of environment and in laws for protection of water and in order to see to it that pollution of water is stopped. The first case which has been espoused, the cause which has been espoused by Mr. MC Mehta is the case of Taj Mahal and its protection from various industries around the corridor of Taj Mahal. We all know, friends, that Taj Mahal is one of the wonders in the world and it is our national monument. And it is a great pride for our country that visitors from all across the world come and take a picture at the Taj Mahal and come and visit the Taj Mahal. But was the Taj Mahal in its pristine state as it is now? No. Few years back, the state of Taj Mahal was quite in a disarray. The reason was not because of the lack of maintenance of the monument itself. The reason was the industries around in the vicinity of the Taj Mahal emitting pollutants in the air, which were really causing problems to the marble construction of the Mahal. Therefore, Mr. MC Mehta filed a petition in the Apex Court and prayed for directions in order to protect the Taj Mahal from the polluting industries. We all know which laws were being considered by the Supreme Court while protecting the Taj Mahal. Those were the Environment Protection Laws, the Environment Protection Act, the Water Prevention Pollution Act, and the Air Act. So therefore, the Supreme Court in the said case for the first time issued strict directions. Now, 2 examples of these are the basic principles which are laid down by the Supreme Court. First is the polluter pays principle. What do you mean by the polluter pays principle? The principle flows from the strict liability concept. And I will come to the aspect of strict liability in my second example of a case. But in polluter pays, the Supreme Court laid down the law that, look, if you are emitting pollutants in the air, you would be held liable and you would have to make good the damage which is being caused not only to the monument in the case at hand, Taj Mahal, but also to various other people whose health may be affected, whose air quality may be affected, whose breathing may be affected due to the pollutants being emitted in the air. The second case which Mr. Mehta, MC Mehta, espoused the cause for was the Ganga pollution case. We all know, friends, that one of India's most important river is the river Ganges. We all know that its origin or the historical origin in Rishikesh, and the situation in Rishikesh till a few years ago was really bad. So much so that we've had several instances of articles coming in various newspapers, being debated on televisions, that the water from Ganga had become so polluted that you could never even think of drinking one bit, forget taking a bath or a holy dip, or for that matter, performing any other ritual, which was in accordance with the historical perspective, the important part of Ganga. So what happened then was Mr. M.C. Mehta led a slew of petitions in the Supreme Court. And the challenge was to the pollution being caused to River Ganga by the industries emitting water in the said river. The Supreme Court espoused the principle of strict liability and applied the said principle, which followed from the famous British case of Rylands versus Fletcher, that you have to be responsible for your own thing, held that the strict liability principle would apply in all those cases wherein all these industries are polluting the environment, wherein all these industries are polluting rivers, and wherein all these industries are causing damage on a colossal note, which will lead to a permanent nature of damage. Friends, we all know that something, a river as important as Ganga, should exist not only for us, but also for the centuries to come. And therefore, the directions given by the Supreme Court were to the strict jacket extent of stopping, of cancelling the permits of all the industries, of refusing permissions for new industries to come up in the vicinity. Well, in a developing country like India, we all face a problem as to how do you balance private interest with public losses. Well, what do you mean by a public loss? Pollution of a river, in my view, would be a public loss. Damage, irreparable damage to one of the wonders of the world would be a huge public loss. Now pitch it against the private right. So what is the private right? Under the constitutional mandate, all and every citizen is permitted to have his own business, but trade or profession. But having said so, that cannot be in contravention with the laws of the land, or that cannot be to the detriment of the environment. And this is where reliance was placed on the strict liability principle by the Supreme Court while directing closure of these industries. We all know that closure is a very serious step which is taken and not taken so frequently. But in these cases, the Supreme Court took a drastic step of closing down various industries in and around the vicinity of Ganges, which were emitting polluting water or which were emitting pollutants in the river. And thus, this principle was espoused. Well, these are not the only two cases. We also have in the year 1989 what was known as the Bhopal gas tragedy case, the Union Carbide Corporation case, which was due to a leak of a gas, and which effects were so far and wide that the area in the vicinity was damaged permanently. The citizens were suffering from various problems, health hazards, and the air was completely impure and was mixed with deadly, what do you call, pollutants, which were emitted, which were leaked by the gas from the Bhopal gas tragedy. Even in that case, the Supreme Court has espoused the strict liability and the polluter pays principle. Well, these are not the only cases. These are cases which were few of the important cases wherein the Supreme Court has issued slew of directions. But now, with the change in environment law or with the change in the scenario, with the development of the country being taken up on a quick note, what has happened is that these laws, which are in that sense old laws, are being replaced or are being fortified with various subsidiary legislations. One example of this is the notification issued by the Ministry of Environment and Forest in the year 2006, which deals with the requirement of a environmental clearance or an environment impact analysis by any project proponent who wishes to have his project or who wishes to carry on a project in India. What are these environmental norms or what are these environmental clearances? The foremost example of a recent judgment is that of the Goa airport case. The Supreme Court bench headed by Justice Chandrachud has held that the state of Goa would be required to procure a environmental clearance if it wants to build a new airport at Goa. The Supreme Court has held that the notification issued by the Ministry of Environment and Forests puts forth certain restrictions on various developmental activities, as sustainable development in India is of great importance. Sustainable development would mean and include that, look, while increasing infrastructure, while building infrastructure, you first meet the standards and norms of requirement. Therefore, on this note, the Supreme Court has held that, look, if you want to cut n number of trees, if you want to have some construction in and around the vicinity of rivers, if you want to have construction in and around the vicinity of an ocean, if you want construction in and around the vicinity of mountains, you will have to go and apply for an environmental clearance, which will be granted by either the State Environment Impact Assessment Authority or the Central Impact Assessment Authority, as the case may be. But it is imperative for an organization, including the Goa government, to have an environmental clearance from the said authority before it goes on with the construction of the airport. Well, a very quick recent example of this in Mumbai, we all are aware of it, is the judgment delivered by the then Chief Justice of the Bombay High Court, Justice Pradeep Nandrajog, mandating the requirement of an environmental clearance for our very own coastal road. We all know that the Bandra-Worli sea link is proving out to be only a stepping stone. And now, in order to meet the traffic woes, we need a longer sea route, which would connect the suburbs in Mumbai to the town areas in Fort and Colaba. So what was proposed by the Bombay Municipal Corporation is a coastal road. I will not go into too many details of the project. We all know that it's going to be a road in the sea, something similar to the Bandra-Worli Sea Link. But I would like to dwell more into what has been held by the High Court. The High Court has interpreted the provisions of the notification, the Environment EIA notification of 14 September 2006, and has held that for the coastal road project, it is imperative that the corporation, Municipal Corporation of Bombay, takes an environmental clearance from the Environment Impact Assessment Authority. In short, it is held by the High Court that, look, if you are going to have such construction in the sea, like a bridge, you must analyze from all quarters the potential damage that it may cause to the environment, like the sea, the potential damage it may cause to the coasts in Mumbai, because the coasts in Mumbai are inhabited. What would happen when there would be huge felling of when we have huge tracts of land which are being developed in and around the vicinity of a sea coast, and what would be the impact of the seawater or the sea line being receded by such construction in and around the sea beds or in and around the coast by virtue of the coastal road. The matter, of course, is presently sub judice in the Supreme Court and is likely to come up for hearing soon. But the present status is such that the bench headed by the present Chief Justice of India, Justice Bobde, has held that construction of only the sea link or the coastal road to continue during the pendency of the matter in the Supreme Court, and no other ancillary development like a park or a promenade is permitted, because that would include land filling, and that would include the land filling to be done around the coastal area. Thus, the Supreme Court has also taken cognizance of such an important aspect. Now, these are not the only two cases, but these are one of the two prominent cases. The other examples of various orders being passed by the Supreme Court are, very importantly, the mining case in Goa, or the Goa mining case. Again, mining is one of the activities which is prohibited in some certain areas like the reserve forests. So how would mining be permitted? Mining can be permitted, can be a permissible activity only in certain areas for certain minerals if the said activity is held to be permissible by the State Environment Impact Assessment Authority or any other expert authority as contemplated under the notification. And therefore, the Supreme Court in Goa mining cases has held that look, Goa is a place which has certain green forests, and although there may be mines in the forests, cutting down of the trees or doing away the green forest cover for the sake of mining would not be a permissible sustenance authority or would not be a permissible sustaining activity for the purpose of a business, trade, or profession. And therefore, to safeguard the environment and to safeguard the forests, mining has been prohibited by the Supreme Court in Goa. Well, I must also tell you, friends, that this has had a huge impact on the economy of Goa and the overall economy of the country. But I believe, in my personal view, that although we should have a sustainable development, permanent irreparable damage to something as important as a forest should be avoided at any cost. Friends, I must quickly give you all an example of what is the position of law in the developed countries as regards forests and as regards other areas. We have in US and in Europe clear restrictions on these activities like mining. And therefore, the companies or manufacturing units which are based in these companies today want to import from India minerals, or from that, for that matter, from a country like China, various minerals, or these minerals from any other developing country which would allow such an activity. So, on one hand, we know that the developed countries are completely avoiding these. And therefore, in my view, our courts, our constitutional courts have taken a great step to see to it that the permanent environmental damage has to be stopped and has been stopped by taking proactive measures, which are not certainly populist measures. Many lives or businesses are affected by these decisions, but these decisions are in the far impacting larger interests of the society. Well, one of the interesting cases which I must discuss is the Supreme Court ban in Delhi on diesel vehicles and the direction issued by the Supreme Court to convert all the vehicles into CNG vehicles. Friends, every year we are now accustomed to in winters or in those months that there is always smog which gathers in Delhi, and the air level or the air ambient level is so poor that there are many people who are suffering from various cardiac and various health related issues and ailments. Not only this, this is causing far reaching impact on the younger and on the newborns and as regards even the health of elderlies. The Supreme Court, while taking cognizance of this, in a proactive move, has directed that all vehicles in Delhi which were leading to air pollution, all those diesel and other vehicles which were leading to and causing pollution, had to be banned. Now, just imagine the kind of loss that the automobile industry would have faced. But in my view, again, the loss caused by automobile industry is the health gain to the citizens of Delhi. And considering the fact that Delhi is our national capital, and considering the fact that the health of citizens of the country in the national capital is deteriorating due to these activities, it is of great importance that a right step has been taken by the Supreme Court. So the Supreme Court directed those buses or those vehicles to be converted to CNG. Now, all these are public utility vehicles, which the Supreme Court has said that look, they will now be on CNG. One other quick touch up upon one of the similar issues is the restrictions imposed by the Supreme Court in case of sale of vehicles which are under what is known as Bharat Stage Compliance 6. So all these vehicles which are say BS4, Bharat Stage 4 or BS5 cannot now be sold in the country. And this is all over the country. So the Supreme Court has played a far-reaching role in seeing to it that the air pollution which is being caused by the vehicles which do not have the latest technology, by which air pollution will be sustained, by which air pollution will be curtailed, has in fact banned the sale of all these vehicles. Another important case which the Supreme Court has taken cognizance of is, friends, the case of Jallikattu and the case of zoos. The Supreme Court has held that animals cannot be treated with cruelty, that you cannot have performances of various cruel nature in order to entertain yourself at the cost of animals. So something like a Jallikattu, which is a national game, which is a state game, I should not say a national game, but a sport or a festival which was prevalent in one part of the country, the Supreme Court has held that it should not be permitted as it causes a harm to the animals. Another case is as regards performance of animals in circuses or performance of animals or animals being treated in a certain way. The Supreme Court has come down heavily on those and has held that look, you cannot have entertainment at the cost of animals. In my view, that is also a very important decision considering the fact that environment is a all encompassing subject. Environment is meant to be enjoyed by every organism living, and therefore plants, trees, animals, people, all of us have to coexist in harmony, and therefore it is important to protect and safeguard the interests of all these animals as well. Well, friends, there are some other cases, but I think due to paucity of time, I will not dwell too much into those. But these are a few examples wherein the Supreme Court has taken a proactive role as regards protection of the environment by passing a slew of measures. I would also like to dwell upon at this stage the third part of my talk, and that is my experiences while dealing with environmental litigations. Friends, I can tell you or I can share with you my first experience was while appearing for the Maharashtra Metro Rail Corporation, which is executing the Pune Metro project in Pune. And the case was that a environmental litigation was initiated against the Maharashtra Metro Corporation in the National Green Tribunal, contending that there should not be construction of the metro in the riverbed. Now, this is an issue of great importance, and therefore, the National Green Tribunal also asked an expert panel or an expert body to submit a report about the status of the river and the health of the river, and whether such a construction would lead to a permanent damage. I must tell you all that as a lawyer, my job to argue in court is comparatively much easier than actually understanding the nitty-gritties of what would be the damage which would be caused to a river or a riverbed by some pillars which are maybe not in the midst of a river but around the vicinity of a river or a flood line. It is at that point of time while handling the case that I realized that environmental litigation or environmental legislation is an expert piece of legislation, and which requires the assistance of not only experts but also of the citizens who are residing nearby and who are going to be affected, perhaps sometimes prejudicially by it. Ultimately, the NGT in that case has permitted us construction, but has told us to take various safeguards. Friends, another important aspect is as regards the case of bullet train in Mumbai now, wherein I've approached the court on behalf of the bullet train for seeking permission to cut some number of mangroves. And it is important today to seek these permissions because under the public trust doctrine, the Bombay High Court in a landmark judgment has held that mangroves would amount to a reserve forest. We all know, friends, that Bombay is surrounded by sea on many of its sides, and it is the mangroves which act as a buffer. Therefore, the court in the said landmark case, it was, I think, filed by Vanashakti or some other organization, I'm not exactly sure, has held that look, you cannot have a rampant destruction of mangroves. Mangroves are a national treasure. It kind of acts as a barrier to stop the flood water or to stop the seawater from entering into the mainland, and thus acts as a buffer. It acts as a forest. It provides for a dwelling house for many of the birds, wild animals, for many of the species which are declining of flora and fauna, and therefore they are to be protected at any cost. And therefore, now for the bullet train, when we have to cut certain mangroves, we have approached the court for seeking a permission. We are also saying that we'll plant 5 times the number of trees. Thus, friends, I can also tell you that we have to take certain measures while considering the importance of sustainable development. These measures include replanting of multiple number of trees that we cut, and for which now various permissions are required. Well, another interesting case which I had an occasion to deal with was a case relating to performance of, or rather usage and performance of various traditional instruments and dances for a Ganpati procession, and also of using a sound system. Because under the noise pollution rules, the municipal administration of Satara in that case had banned all the performances, all the usage of the instruments, and of all devices which would make certain sounds. While arguing before the High Court, I had the occasion to convince the High Court to allow us the usage to an extent that it is permissible under the rules, and only on an express undertaking that those rules would be adhered to, the High Court granted us permission. Even at that point of time, we had to really give examples of various types of sounds and the impact of sound pollution on environment and on individuals to the court. And the court, after looking into all the measures and only on certain various conditions, permitted us the usage of these devices. Also, friends, we must understand the kind of impact that these instruments or that these activities, which may look to be temporary, might in fact be permanent in nature, and therefore it is our responsibility also to see to it that we always safeguard the environment as our first priority. In some of the other cases in which I have appeared are issues relating to procurement of an environmental clearance. And this is always, environmental clearance is always a very debatable issue, wherein the project proponents would often say that they do not require environmental clearance. And whereas the government authorities or some private individuals would say that the projects would require environmental clearance. I must tell you all that ultimately in recent times, the Supreme Court has even gone on and held that construction activities which are above 20,000 square meters would require an environmental clearance. This was held and reiterated by the Supreme Court in a recent judgment. The Supreme Court has time and again held that all activities in relation to construction or all activities of development would have to be on measures which are provided for the safeguarding of the environment, as large scale development may also cause unwarranted destruction of the environment. And the unwarranted destruction is to be avoided by taking up of the safeguards. And the safeguards are to be implemented in accordance with the norms of the authorities. In Bombay, we also have various issues relating to wetlands. We have various issues relating to coastal zones. And I have also had the occasion to deal with those issues as regards seeking of permissions from those authorities. My brief experience has been such that in these situations, it is important to seek those permissions before going on with the project activities, as these are expert bodies which are formulated under the contours of the Environment Protection Act. The MCZMA, the Coastal Zone Authority, or the Wetland Authority, or even the Tree Authority, are expert authorities which are dealing with these issues, which are of utmost importance today. And therefore, while dealing with them, we have to also maintain a line and a balance to see to it that private interests do not destroy the environment or do not cause a long-term loss. Thus, friends, to sum up, I would like to say that today we are facing a dilemma about the environment impact assessment draft notification which has been propounded by the national government, and on which a huge debate is taking place as to whether such a notification is sustainable or such a notification would require various changes in its form. I would like to say that the debate at some point of time would be put to rest by the Supreme Court, and hopefully before that by the central government, by seeing to it that it is a balanced piece of delegated legislation or a notification, so that private interests do not override the interests of the whole country and its environment. But we must also consider the pious objective of the 42nd constitutional amendment while we deal with environment. Friends, we must realize that after so many years of independence, it is not only the job of the state under the directive principles of the state policy to protect the environment, but it is also a fundamental duty. And therefore, as our fundamental duty, it is our involvement and it is our participation in protection of the environment which will be of great importance. It is our responsibility to see to it that the environment is safeguarded not only for the present times, but for the times to come, and in the times that India will be a developed country. And with its flora and fauna, with its animals, with its birds, with its rivers, with its mountains, we have the Himalayas, and all other natural beauties intact and to be enjoyed by the generations to come. Thank you.
Thank you so much, sir, for that wonderful session, the insights that you have provided to the participants. I'm sure they have learned a lot within an hour, starting from the Stockholm Conference to the constitutional aspects, the amendments. Thank you so much, sir. So with your permission, can we take up few questions of the
Yes,
participants?
of course. So I did not know how much time it would be. So therefore, I was kind of restricting my talk so that we could spend more time on the questions. The
Sure.
reason being that the topic is too vast to sum up in 1 hour.
So I'll take up the first question. It's
Yes.
from Aishwarya Pradhan. She is asking if the Supreme Court held that animals cannot be used for entertainment,
Yes.
then why zoos cannot be banned? Zoos are the prison houses where innocent animals are trapped for their lifetime. Is there any case filed regarding banning of zoos?
Yes. I would like to answer that question straight away. Look, the Supreme Court, in my view, has drawn a line when it comes to various sports or games or cultures or traditions which are grossly harmful to the health of animals. Now, example was of Jallikattu, which included that the bulls would be injured or whichever animals would be injured. Similarly, is the example of those races in Maharashtra, which have also been banned, or for that matter, as regards one festival in relation to snakes in Maharashtra, wherein which was also banned. But as regards zoo, I don't think that the Supreme Court has banned it for a reason that in zoos, the first of all, zoos would come under the ambit of the Wildlife Protection Act. And thus, when there is a statutory framework provided, there are various norms which are established under the zoos. And there are conditions in which the animals are to be kept in zoos. And therefore, because it is under the statutory framework, it cannot be banned. Of course, if there is an instance of a singular instance of a zoo of an animal being mistreated in a zoo, that can certainly be looked upon by the state high court or directly by the Supreme Court. I think, madam, that would answer the question.
Yes, yes. Thank you so much, sir. Sir, one question has been asked by two of our participants,
Yes.
Kirti and Sutapa. They are asking, does any individual has a right to sue on behalf of the municipality where they live in?
Does the individual have a right to sue On behalf of the municipality? Against the municipality or?
On behalf of the municipality, relating to the cleanliness matters into their vicinity.
Okay, look, an individual can certainly approach the National Green Tribunal, which is the expert authority, for the purpose of maintenance of, for if the local authority fails in its important function of providing a clean environment. Therefore, if I have understood your question correctly, you want to ask me if you can approach the court against the local self-governing authority for any violation. Yes, you can. You can certainly file a original application in the National Green Tribunal.
Next question is from a YouTube viewer. It is R.A. Naik. He's asking whether principle of sustainable development is implemented in India. If yes, then why do we cut thousands of trees under the name of highway constructions?
Yes. Well, see, friends, I must tell you all that when we are dealing with sustainable development, in my view, in my opinion, it cannot mean that you cannot have any sort of development. Nor does it mean that you can have rampant cutting of trees or forests. The balance of consideration insofar as requirement of a road, qua the cutting of trees, has to be by the authorities or the planning commission or the government, as the case may be. If the government so feels that for the purpose of maintenance of governance, for the purpose of trade, for the purpose of, say, protection, if it is the northwest frontier, some forest regions have to be cut, trees have to be cut, a road has to be, a highway has to be made, then I don't think the courts are in a position to stop that sort of a construction. But if suppose the court feels that there is unnecessary cutting of trees under the name of sustainable development for the purpose of a road, then certainly there have been various instances wherein, as I was explaining, the courts like NGT have established bodies of experts to analyze whether such a requirement is necessary and is prudent. And on that basis, certain projects have also been stalled. For example, the Bombay Coastal Road. The High Court held that, look, you can go ahead with the construction on the ground of sustainable development because today traffic is a problem in Mumbai. But you can go ahead only when you obtain an environmental clearance certificate, because that is the kind of certificate which will give you a clearance as regards the protection of water bodies as well. So it's a balance which the courts have to achieve.
Sir, the next question is from Mr. Prasad. He's asking, sir, I would like you to tell us about the current situation of Western Ghats, mining being carried out in such an environment which has multiple species of wildlife.
Yes, I think this is a very important question. The Western Ghats are one of the nature's beauties in the country. The Western Ghats are, in fact, the Western Ghats go from 5 or 6 states, and they are one of the most pristine surroundings or one of the pristine range of mountains that we can have in our country. Now, as far as I am aware, within 1 kilometer radius, there is a notification within 1 kilometer radius from the boundary of Western Ghats, mining activity has been prohibited. The same example has been, the same notification has been used and has been set into motion by the Supreme Court while banning mining in Goa. It held that you could not have mining as a commercial, as a rich commercial activity within the vicinity of 1 kilometer from the boundary of forest. If Mr. Prasad finds that such an activity is happening, then he should take up the issue, because in my view, such an activity is not at all permissible in the forest and certainly not in Western Ghats. There have been various reports as regards Western Ghats. As far as I know, there is a Gadgil committee report which has given out the particulars of the Western Ghats, the details of states from which the range goes, and the norms and activities which are permissible. So the state authorities, in my view, as far as I am aware, are taking up various measures to see to that the Western Ghats are protected.
Thank you so much, sir, for that answer. And I am sure that that participant would take some action if he has noticed something.
Yes.
The next question is from Sarita. She is asking, so many stray animals and birds are killed in road accidents or in neighborhood, citing safety reasons. Are these acts questionable under any provisions?
Look, if it is stray birds and animals, and if they are causing nuisance to the local inhabitants, this can be a dangerous situation because I am also an animal lover. I also know the importance of even some strays. They do provide a lot of comfort also at times to many individuals, and they also are guaranteed all the rights and safety requirements which are for their benefit. But having said so, if certain animals are causing huge nuisance, such animals are causing a situation for the local inhabitants, then obviously there are no restrictions on the authorities to take the required actions. Of course, that does not mean that the authorities go on killing animals, stray animals. That never happens. If something or the other sort happens, like for example, I know of an incident in Solapur when there were many dogs, many stray dogs, which were causing a great hindrance on few of the important roads. Such was the situations that some people could not walk on the roads without having the fear of being bitten by dogs. And some people were in fact even thinking of approaching the High Court and seeking action against the corporation to take some measures against those dogs. Friends, we must understand that it is the local self-governing authorities, the corporations, the municipal councils, the village panchayats, Zilla Parishads, and all other authorities which are empowered to take actions so as to consider the interests of the inhabitants. And these authorities have to take measures for the safeguard and well-being of the animals.
Thank you, sir. The next question is from Kumar Saurabh. He's asking, what are your views on the violation of CRZ in Mumbai, like the new international airport and also the Shivaji statue construction?
That's a very prevailing question right now in Mumbai. The answer is simple. The Mumbai airport, in my view, because I am asked the question individually, I would say that would have to follow the judgment of the Goa airport. The reason I gave that example was that, look, in Goa, Justice Chandrachud's bench has held that the authorities would require an environmental clearance. And in my view, there should be no reason why in Bombay the same should be followed. Now, as regards the Shivaji statue, I think that matter is already sub judice, if I'm not wrong, before the courts. And I'm sure the courts will decide whether there is any requirement of law for the purpose of the same.
So the next question is from Karuna. She is asking, sir, could you please tell us about what is radical environmentalism?
Yes. Radical environmentalism would have two connotations. One would be that you would be hurt even if a stray dog is not being fed. The second would be that you would say that, look, development may be so, development, okay, but then you will not cut these trees. So you have a metro and there are some 100 trees and the metro has to go through them. That you say that, no, look, you go underground or you build a bridge over those trees. And that, in my view, would be radical environmentalism. That's first connotation. Second is you say that, look, you cannot have this project at all. Why? Because you may cut some trees. No, you cannot. So that amounts to radical environmentalism. I don't think that is correct. You cannot have a complete ban. You have to find a midpoint to see to it that there is a balance achieved. Therefore, when I said that NGT is doing a great job, I believe that having an expert member as a panel judge really takes care of all these situations.
So the next question is from Hina. She is asking, so what are your views relating to the RA colony case?
Friends, the RA colony case is now also sub judice in the Supreme Court. what has happened is that there was a PIL filed in the High Court saying that the RA colony constitutes a reserve forest, and therefore under the contours of the reserve forest you just cannot cut trees and you cannot have a shed for metro there. I must tell you all that as much as I am also concerned for the trees, the High Court has held that look, it is not a reserve forest. Now, this is a judgment given by the very same judge, Chief Justice of the Bombay High Court, then as he was, Justice Pradeep Nandrajog, who has held that EC is required for the coastal road. So the judge has held that look, this is not a reserve forest. That argument is held as not being correct, and therefore the judge has held that look, you cannot have the contours of a reserve forest for RA, and therefore you can go ahead with the project on conditions. Now the Supreme Court has also permitted work, and therefore now the matter is sub judice in the Supreme Court. Let us see the outcome of the Supreme Court proceedings now.
Thank you so much, sir. The next question is from Dr. Nasir. He's asking, what are the main challenges faced by Forest Department in implementing the provisions of Forest Conservation Act 1980?
At this stage, I must first tell you all what is the problem with the legislation in order to understand the problems being faced by the authorities. We have two acts. One is the Indian Forest Act of the year 1927, and then we have the Forest Conservation Act of the year 1980, and we are in the year 2020. In my view, we are long overdue an overhaul of both these acts, and there should be one single legislation which provides for a policy for safeguarding of the forest, which empowers the authority to take care of the forest for the next, say, 50 years. And therefore, both the acts, which are one act is almost 100-year-old, the other act is 40-year-old. Therefore, both these acts should be done away with. You have a present day act which will consider and which will empower the authorities sufficiently to deal with problems today. Friends, when those acts were enacted, we don't know what was the situation of mining. We don't know to what extent was developmental activities causing hindrance. Now we only have a notification, that is the EIA notification, but we must also strengthen the acts in itself in order to provide assistance to the authorities to deal effectively with the problems of implementation of those laws. That is my view.
Thank you, sir. The next question, sir, with your permission, can we take a few more questions?
I would be more than happy.
Thank you, sir. Thank you. The next question is from Mr. Rochit. He is asking, can a legitimate plaint be filed against China for the widespread of coronavirus and adversely affecting the environment?
Well, I think such a plaint has already been filed in some court. I think it has been filed in one of the American courts. In my personal opinion, I believe that, look, they could have maybe closed their boundaries so that the disease would not have, the COVID-19 virus pandemic would not have spread to other parts of the world. But as regards filing a plaint, I'm not so sure that the statutory global framework provides for such a platform. And therefore, in my view, at this stage, it would be really difficult.
The next question is, can COVID-19 be an opportunity to increase people's sensitivity towards the global crisis, such as the climate change?
I think it is a very important question. I think it is a very correct question. We must use this COVID-19 as a situation to fight various problems that we face in our country today. One of them being the climate change problem. Look, we are in the month of August today, and we see in Maharashtra, what has happened to the rainfall over the past 3 years? Well, our monsoons begin in June, but we usually don't have rains in June, July in Maharashtra anymore. This is because of the climate change, and we must sensitize our citizens, our people about climate change in order to see and safeguard a better future. The person who has asked the question is right there. I believe so too.
Thank you, sir. The next question is from Dr. Rudra. He is asking, why are the Wildlife Protection Act not properly implemented by many states of India?
That's a policy issue, Dr. Rudra. And to go into a policy issue, would entail a far deeper conversation than what we are having today. Let us hope that all the states do become sensitive to these areas, and let us hope that we have far better protection of environment by the authorities.
Thank you so much, sir. So the last question for the session, Lizella Colalo, she's asking, respected sir, what are your views about the illegal mining activities that deteriorated the environment despite we having the Environmental Protection Act 1986, despite these stringent laws?
Yes. So for mining, the law relating to mining is twofold. One is the Environment Protection Act. The second is the EIA notification of 2006, which also bans mining as an activity in various areas, like a reserve forest, like a forest. Now, this is exactly the principle which has been laid down by the Supreme Court in the Goa Mining ban case. Now, we all know that banning of mining has had a huge impact, but there cannot be, it is a clear proposition of law that there cannot be mining in reserve forest or in forest areas. You cannot have mining activity going on because mining really leads to destruction of trees, forests, and of the area. And therefore, if such an activity continues, the person perpetrator should be punished in accordance with law. That is my view.
Thank you so much, sir. Thank you for answering those questions. I can see the questions are pouring in, but we do understand due to the paucity of time, we need to stop somewhere. Thank you so much, sir, for this wonderful session.
Thank you.
I am truly enlightened with the discussions by the case laws, by the practical views that you have given to our participants. Thank you so much, sir.
Thank you.
I request Khushbu to kindly propose the vote of thanks.
Thank you so much, Pooja ma'am. It's my privilege to propose a vote of thanks on behalf of this esteemed institution, KLE Societies, KLE College of Law, Navi Mumbai, for this event. I would like to express my gratitude and heartfelt thank you to Advocate Pralhad Paranjape sir, who, despite of his busy schedule, found time for this to honor this session with his inspirational thoughts and educating all of us with such an informative session. Sir, it was indeed a wonderful lecture. Thank you so much, sir, for making this webinar interesting. We all gained a lot from you, sir, today. I would now take the privilege to thank our respected members of KLE Management, Dr. Prabhakar Kore, sir, Chairman of KLE Society, Mr. Mohantesh Kavatimat, sir, Governing Body Chairman, with KLE College of Law, MLC and Chiefs with Government of Karnataka. Dr. Malika Arjunaya, sir, Principal of KLE Law College, Bangalore, and Director, KLE Law Academy, Bangalore. And our respected principal, sir, Professor Dinkar Gitte, sir, for their blessings and guidance. I'm also grateful to our teachers, Dr. Amrita Singh ma'am, Professor Pooja Bijargi ma'am, Professor Sri Vidya ma'am, and Professor Mohammad Salim Khan, sir, for their continuous support and guidance. I'm also thankful to our student convener, Shama, Atul, and Roshan, and the whole team for their continuous support for the webinar. And last but not the least, our dear participants for coming in a huge number and making this webinar a huge and a grand success. Thank you so much, all.
Thank you so much, sir. Thank you.
Thank you.
So with this, we end the session.
Thank you.
Participants.